All right, this is file 181041. It is Joseph Harvath versus Katie Harvath. And this is the decision following the motion for reconsideration. The hearing in this matter on this motion was April 28 of 2022. Previously, on January 13 of 2022, the court had issued a decision, and this was related to the use of the economic stimulus payments that were received by Joseph Harvath related to the minor child, Brooklyn Harvath. And at that time, the court found that the $2,000 that he received should have been paid to Katie Harvath, who these all related to 2020 benefits. And the court found that the stimulus payments were intended for people who were actually taking care of children, and that the Brooklyn was with Katie Harvath during the entirety of 2020, and therefore the $2,000 should have been paid to Katie. And in fact, they were paid to Mr. Harvath as a result of him claiming the minor child for federal income tax purposes. And at that time, well, in an order entered, I put the opinion on January 13, but the order provided that Joseph Harvath was ordered to pay Katie Harvath a total of $1,000 by June 1st of 2022. And from that point forward, Katie Harvath would receive all rights to make any claims related to tax benefits for both minor children. Following that decision, the plaintiff, through counsel, filed a motion for reconsideration. And that was and we had the hearing on that on April, I think I said 28th of this year. And what he asked for was to set that order aside, and part of what he argued, we made two things. Number one, he argued that he argued the same thing he argued before, that it was a tax benefit and he was entitled to claim all tax benefits. And also, he argued that it was improper for the court to modify the child support provision, or I'm sorry, to modify the income tax benefit provision of the judgment of divorce, because the court lacks authority to do that. And I can't recall if he had this in his pleading, but to an extent, he's correct. He's incorrect when he characterizes it as a retroactive modification, because that is not what it is, in the sense that we use that term for child support situations. But the court is not permitted to undo a tax benefit clause in a judgment if that tax benefit clause was part of the property resolution, or in other words, not tied to the child support resolution in the case. And there is nothing in this file to suggest that, in fact, the income tax dependency language, let's get to that. This is on page 3 of the judgment of divorce. It says, the parties shall each claim one child for income tax purposes. And then parenthetically, it says exemptions, deductions, credits, etc., so long as 2 children are eligible. When there's only one child remaining eligible, the parties shall alternate claiming the child for income tax purposes with plaintiff claiming an even numbered years and the defendant claiming an odd numbered tax years. The parties shall cooperate with each other and sign any documents or forms which are necessary. And then again, parenthetically, currently IRS Form 832, close parentheses, to effectuate this provision or be subject to the contempt powers of this court upon their failure to do so. So that is the provision we're talking about. And going through the file, and I said this at the hearing, it is apparent to me that that provision was not reached as part of any child support determination. And when we had the hearing for reconsideration, it was in fact determined that nobody disagreed with that. Nobody disagreed with the idea that it was not part of the child support calculation. So because of that, I do find as a general statement that it was, the court did not have the authority to simply change that provision. And so that part of the order I'm going to grant. Now, I do believe that I could, if I had found fraud or if I made a contempt finding, I could make that change. Much like in other property situations where someone's not complying with a provision of judgment of divorce regarding settlement, the court has the equitable authority to say, guess what? You're going to sell that boat and you're going to pay for what you were supposed to pay for already, or you didn't turn over certain property. So guess what? That the other spouse is going to get the car. The court does have the authority to enforce provisions or exercise contempt powers, but I didn't make any of those findings. So I'm not going to go down that road at this point. However, let's get back to the main issue, and that is this idea that counsel insists that that judgment of divorce provision means that Mr. Harvath is entitled to the economic impact payments. That's just simply not accurate. The economic stimulus bills, I can't remember the names. One's referred to as the CARES Act, the other as I think the Coronavirus Relief Act. None of those are part of the income. The IRS is not in, the tax code was not modified as a result of those acts. Those were emergency pieces of legislation, and the intention of that was absolutely to put money in the hands of the people who needed it most. The amount of money that a family was to receive increased by the amount of people in your family, dependents. And so the easiest way for Congress to get that money in the hands of various people was to say, well, we're going to use their tax filings to figure out where these kids were. So I found one quote from back in 2020. Congress is looking to pump money out to taxpayers as quickly as possible to weather this crisis, and they are using information taxpayers provided on their returns to quickly figure out who's going to qualify and how to get it to them as quickly as possible. They used the information on their tax filings to determine where to send it. It's not that those tax filings entitle the people to the stimulus relief money. It's just that was the easiest way to get it in their hands. So this is not, this is the stimulus payments were not a tax benefit. And what counsel for the plaintiff wanted to argue was, well, this is a tax benefit. This is a this is something that you would get because of your tax benefit that was awarded to you, and that is not true. They only used it as a vehicle to identify where people actually were living. And if you think about it, somebody in a little cubicle wasn't going to call every family in America to figure out, okay, are your kids really there? Are you really there? This would probably take care of 98% of the people out there. And the 2% where kids were actually living elsewhere, they should have, if they had asked for it, they should have got the money. I don't know if the IRS has, if they have a policy to get that money redirected to where it's actually intended. Are they saddled with that determination? I don't know. All I know is it is abundantly clear that these acts were intended to put money into the hands of the people that needed it. This isn't I'm not imposing my view on this. This is not even disputed. You couldn't, when this was going on, you couldn't find, I still don't believe you can find a single piece of information out there that suggests to the contrary. They gave extra money for the extra dependents who were living with people. And again, to say that this is you got this because you were able to claim the person, and that it's a tax benefit is not true. In fact, people who didn't file at all and weren't claiming had a path to get the money. So it was the only thing is it was the easiest way to identify, and it's not part of the tax code. These were separate and independent acts, and they only utilized the dependency exemption because it was easy to then get the money in the people's hands. And I think for most people, it got in the right hands. Mr. Harvath was not the right hands. And therefore, he must pay the $2,000 of that was related to Brooklyn for 2020 that he received. He is to have paid this in its entirety by the first 1,000 is to be paid by July 1st, 2022, and the other 1,000 is to be paid by December 1st of 2022. And I will say, in the event that he has not paid this money by March of 2023, then he will be precluded from claiming any tax benefits related to the other children until such time as he has paid the $2,000 in its entirety. So what is clear here is I am not taking the ability to claim anything that he might have been entitled to under the judgment of divorce from this point forward. It is only until such time as he has paid the $2,000. And I think, we might come to a different, I think that if I had made a finding of contempt, I could have taken that deduction from him, and I'm not saying I would find him in contempt, but that would give the court the authority to alter some of this. I will take care of the order in this matter and send it to the parties.